Chris Vanderveer, The Condo Shop, 267-344-6200, Philadelphia Property Market. Video 4, The Nuances of the Agreement of Sale. In buying a property or bidding one, you have probably seen a document or heard of one called the Agreement of Sale, or AOS, as it is known in the real estate trade. Probably no one, with the exception of a seasoned real estate professional, knows all of the nuances and clauses of this document, so relax. The document is provided by the Pennsylvania Area Realtors Association and is standard to all real estate transactions in the state. It well protects the rights of the buyers and the sellers. Developers may have their own agreement of sale. However, this incorporates general elements of the standard agreement of sale with the particulars of their development project as required by their lenders. When in doubt, have your own attorney review that document, because those documents can have a lot of very important changes to them that you're agreeing to. The most important part of the document is the amount bid. Buyers want to bid low, sellers want to see a high bid. Only you can decide the price that you're willing to receive. For bidders, the longer the property is in the market, the lower the amount they bid will be. If you are selling, only you know how desperate you are for the money from the house. Bidding 10% off is no big deal today. It is the norm for any statistic in the area of property market sales. As a seller, there are two aspects to bid aside from the price. Well, there's more than two, actually. There is the closing date. How fast do they want to close, and does that fit your schedule? How much money are they putting down within how many days? And are they vested in the deal, or can they walk away at any time without any repercussions? You need to set the rules and determine how the contract will go. Of course, once you set the rules, they have the option of walking away. The most important fact to determine is whether the buyer can close the deal. Along with the submitted agreement of sale is always a statement of mortgage prequalification. This states only what the bank would lend to a potential buyer based upon his financials. The amount actually lent on the specific property depends upon the property itself and what it appraises for. For cash deals, the buyer needs to show only that they have the money in the bank to do the deal, usually liquid funds or some stock account. Properties are usually expected to close within 60 days from the date that the agreement of sale is executed, that is, agreed to by both parties. In these troubled times, that period has been extended. Closing of 4 months from now is better than nothing at all. The closing date is something which is a critical factor to the agreement in both parties. A property where there are cash funds available and the title can be cleared can be closed within 2 to 3 weeks. Cash is king, and it's easy to transact the property. You'll notice at the closing table it's all mortgage documents that get signed. When you pay cash, the binder is about 5 pages thick. Included in the contract, the buyer has the right to inspect the property. The typical period for this process after signing is 15 days or less. Inspections and money back are tricky, and it's easy for them to kill deals. Many times buyers want a lot of things off the price the seller is not willing to give them. When you go to sell your property, a real estate agent will have you fill out what's called a seller's disclosure. The seller's disclosure tells the potential buyer all the positive and negative things that happened to your house, condo, or unit during the period that you owned it. It is best to be honest on the seller's disclosure, because if problems are not reported, the red flag is raised when the buyer inspects the house. They ask themselves, if the homeowner is lying about the inspections to the house, what else can they be lying about? Maybe the roof's ready to collapse, or the pipes are ready to burst. Who knows? It just creates suspicion. Just be honest on the inspections report, or the seller's disclosure. The buyer will, of course, hire a certified home inspector to verify everything that you mentioned on the seller's disclosure. On the contract, there are two options, option 1 and option 2. The best option, I believe, is option 1. This allows the buyer to inspect the house and come up with the item report and ask for money off the transaction if defects are discovered. It is then up to the seller to grant them that amount of money, or hopefully for them less. Option 2 allows the owner to correct the problems. This choice is probably only good if the seller of the property has also built the property, such as a construction company or developer. They usually have construction people on staff night and day to repair a problem and can do so effectively for their own pricing. The agreement of sale contract is over 10 pages long and needs a legal head to define all the clauses. Of course, it's a document which can be changed. You can add an addendum at the end of it. One major contingency factor would involve a buyer selling a property before they buy yours, or a contingency that they get a mortgage by a certain date. Try to avoid contracts which are contingent on anything. Not always, however, easy. For buyers and seller, if you trust the agent you hired, just ask their opinion on getting the deal done in the way which benefits you the best. Experienced agents have written hundreds of contracts and know how to move the process forward efficiently and, again, how to make the best deal for you. Remember, any missed contract date on the contract renders it null and void. If a buyer is required to put in a deposit by, let's say, December 10th, but they do not come up with that deposit, the seller has the right to tear up the contract and look for other buyers. However, in these stressed days and with lack of buyers, people would probably not walk and work it out. It's hard to get a mortgage these days. It's hard to come up with the money. 10 years ago, there were multiple property offers, and buyer number one, if he was out of contract, would probably be out of luck. Finally, if the buyer has a large deposit in the deal and has gone past the escape date where he cannot leave the contract, and he leaves the contract, the seller has the right to keep that deposit if he does not close. I have never seen a situation where a buyer puts in a large deposit and walks away. They just don't want to lose the money. The contract usually limits the seller and the buyer to damages only relating to the loss of money, not mental pain or any other legal action. Thank you for watching video number 4, Chris Vanderveer, The Condo Shop. The nuances, the agreement of sale, 267-344-6200, Philadelphia Property Market. Thank you.